Hi there, students. Well, in this online lecture series, we are going to proceed with respect to the discussions that we started on forest related conservation laws that we have in our country. Now, the next discussion that we have with respect to forest law is related to forest rights. Now, in the previous two lectures that we discussed, we have seen how the Indian forest laws has evolved over the period of time, have evolved over the period of time. And in fact, the law that we had 1927, it was primarily very revenue oriented. While after independence, not so much changed, but still we shifted our gear and then we had a conservation oriented approach. But despite this fact, we had that colonial hangover for quite a long time. And that is a reason because of which the forest rights of those who were dwelling in these forests for so long, for generations, their rights were never recognized. In fact, in the pre independent era, there was one legislation which, of course, I have discussed in the previous lecture, where the forest dwellers, their rights were recognized up to a certain extent, but that law was also repealed. However, when it comes to independent India, well, when it comes to foresters, they were very much, they used to perceive the forest dwellers, of course, as encroachers. Now, the thing is that this shift uh, of colonial hangover on one side to conservation preservation of forest on the other side was taken to a different new level after legislation was adopted and enacted in the year 2006, also known as the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Rights Act 2006. So we'll discuss about this legislation in today's lecture, and I hope that you will follow what I am discussing, and you'll also follow up with other available literature. There's one literature I'd definitely like you all to refer to, which in fact was also referred by me and my professors used to, refer to that to that literature. It was by of course, it's related to Forest Rights Act. The title of that article is The Indian Forest Rights Act 2006, A Critical Appraisal by Lavlin Bhullar. Now, the thing is that if you refer to this legislation, there are several key features that you will come across. In fact, for the first time, as I mentioned, the rights of the forest dwellers were recognized. And what are those rights which were recognized? Well, are there any categories of forest dwellers that you have? Of course, from the title, it's pretty much apparent that you have the scheduled tribe forest dwellers and you also have OTFDs, so called other traditional forest dwellers. So there are two categories of forest dwellers. And what are the decentralized structure that you have with respect to recognition of these rights? How are you going to recognize that rights? What are those rights that you are recognizing? So this is what we are focusing on at this point of time. Now, if you refer to the history, which I have just mentioned, the thing is that we had a long history of injustice, and in fact, injustice towards whom? Injustice towards the tribal communities, towards the forest dwellers, for because they were the one who were deprived. They were insecure about the tenure. They were having the threats of eviction for quite a long time to be alienated of their tribal communities and from their ancestral forest land itself. Now, this historical injustice was in fact perpetuated by several other legislation, including the legislation that was there after independence. Say, for example, the Wildlife Protection Act of 1972, then the Forest Conservation Act, which I discussed in the previous lecture of 1980. Because these laws, although they identified environmental protection, but at the same point of time, when it comes to recognition of the rights of the tribal communities, this is somewhere we will find there are certain glitches. Now, the tribal agitation, something which started at that point of time, because for quite a long time they were on the receiving end, and the Ministry of Rural Development, Government of India, decided to constitute a committee. And if you see, in addition to that, there is also an amendment in the Constitution, the Part 9A of the Constitution, which in fact talks about panchayats to schedule areas, which are primarily tribal areas identified for special protection in the fifth schedule of the Constitution, right? Now, in addition to that, the Ministry of Rural Development, Government of India, constituted a committee, and this committee was headed by Mr. Dalip Singh Bhuria, also known as the Bhuria Committee. Now, the Bhuria Committee report came in the year 19. It was released in the year 1995, which inter alia argued that there is a dire need for recognition of the Gram Sabha, also called the Village Council, which comprises of assemblies of all these adult residents of the village, and they should be the so-called primary center of the tribal governance. In addition to that, it was also recommended that there is a long-standing demand of tribal control over these so-called forest land, the productive land, which has been conceded to administrative interference for quite a long time. In their affairs, of course, it is something which this committee suggested should be minimized. So, administrative interference in the affairs of these so called forest and other tribal areas should be minimized. That is what the Bhuria Committee also suggested. And in fact, following this report, the parliament in fact passed the Panchayat Extension to Scheduled Tribes Act of 1996, also known as PISA. And this particular legislation recognized the rights of the tribal for self-governance to self-governance. So keep this in mind that PISA, so-called Panchayat Extension of Scheduled Areas Act, is the one which recognized the rights of the tribals to self-governance. But the actual implementation of PISA was well not that satisfactory. Now, there was also certain shift which we have also seen because, on one side, the Ministry of Environment, Forest and Climate Change was there pretty much, and on the other side, there was this Ministry of Tribal Affairs, which was also trying to address the issue of historical injustice which been suffered by the tribal communities for quite a long time. Now, the thing is that this legislation which was enacted was, the Forest Rights Act, so called the Scheduled Tribes and Other Traditional Forest Dwellers Recognitions of Their Rights Act 2006. This enactment was not that easy. It was not a easy legislation to come up with. So that's the reason because of there were certain debates which were also there prior to that. The debates were between the activists, the environmentalists, conservationists, foresters, and so on and so forth. The thing is that it is important to consider that the reasons for the emergence of this legislation is in the face of such divisiveness is itself, which highlights the paradigm shift in the approach. Now, what happened is that on one side you had this Ministry of Environment, Forest and Climate Change, which in fact was accused of misinterpreting the judgment of Honorable Supreme Court in TN Godavarman Thirumul Par versus Union of India in the 2001 case. Now, it was alleged that the ministry, in fact, failed to understand the judgment in true sense. It misinterpreted because the judgment required any regularization of forest encroachment to be cleared by the court as a direction which to summarily evict all the illegal encroachment of the forest lands, right? But in this judgment was misinterpreted, and the Ministry of Environment, Forest and Climate Change, in fact, perceived all the forest dwellers as encroachers. You should also keep that in mind in between this entire timeline. In 1988, the National Forest Policy was also adopted, right? Now, going to that, the National Forest Policy of 1988 highlighted a need to involve tribal communities in the management of forest. And in order to implement this policy, the Ministry of Environment Forest released around six sets of circulars. It was way back in 1990. Now, at that point of time, they clearly highlighted that there is a dire need for regularization of these so-called forest lands, and in order to do so, the tribal communities should be involved in the management and regularization, provided the state government should evolve certain eligibility criteria in order to, identify and also to take into consideration the local needs and the conditions. But unfortunately, this people oriented process was never implemented in true sense. It was never implemented at all. So, National Forest Policy, although it was a very dynamic policy document, and despite the circulars which were adopted by the Ministry of Environment, Forest and Climate Change, it never saw the light of the day. Now, after that, as I mentioned a while back, that the Ministry of Environment Forest also misinterpreted the judgment of T.N. Godavarman. It started evicting people who were there. And at that point of time, it was usually after the general elections, and the then government, I believe it's the United Progressive Alliance government, which of course decided it was committed to discontinue the eviction of these tribal communities and other forest dwelling communities in that particular area. And what happened is that a task was assigned to the ministry, of course, not the Ministry of Environment, Forest and Climate Change, but the Ministry of Tribal Affairs. It was the Ministry of Tribal Affairs which constituted a technical resource group which comprises of several representations from respective ministries, civil society organizations, etc., etc. And finally, this bill was adopted, also known as the Scheduled Tribes Recognition of Forest Rights Bill 2005, although the term other traditional forest dwellers were not there in the title of the bill. Now, of course, it received severe opposition from several parties and several fronts in several quarters. In fact, as I mentioned, the wildlife conservationists were also expressing concern over this because this was kind of also challenging the concept of this protected areas, and also wildlife conservationists, foresters, they were quite hesitant to put forward this, take this bill forward. However, a joint parliamentary committee was formed. The bill was referred to that joint parliamentary committee in order to settle these differences. And the joint parliamentary committee also gave certain recommendations, which was in fact presented in front of both the houses of the parliament in 2006, where it was again very much contested by the conservationists. Now, in order to resolve the crisis, a group of ministers were also asked to arrive into consensus. And finally, they all agreed to come up with this legislation called Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Bill 2006. It was a revised bill now. But this bill was also criticized, so on and so forth. There were several such, and the JPC's recommendation was also diluted by the group of the ministers, and there were certain modifications which were also made. So, nevertheless, the revised bill was approved, and the act was passed by Parliament on 18th of December 2006. And thereafter, the Ministry of Tribal Affairs also set up a technical support group to prepare, this so-called rules for the same, which we also known as this Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Rules 2007. So, in order to supplement the procedural aspects of the FRA, so-called 2006 legislation, so final rules were also adopted, and it was notified after 2 years in 2008 January. But unfortunately, despite all these attempts which were made, there were certain debates and challenges which were put forward by several stakeholders. Now, with respect to the features, this is something which I would like to discuss. There are certain key features of this legislation. First and foremost is that the purpose of this enactment, FRA, so called the Forest Right Act of 2006, was to recognize the rights of forest dwellers communities, and not just that, but also to encourage their participation in management and conservation of wildlife and forests. Now, the interpretation and implementation of this act has to be determined, and of course, there was no such comprehensive resolution at that point of time. But over the period of time, what we have seen, several key factors were also emerging, and judicial interventions were also there, and so on and so forth. Things changed, and in fact, the ambit of beneficiaries of this particular legislation also expanded, because initially only forest dweller scheduled tribes were the sole beneficiaries of the act. However, the other non-tribal forest dwellers were not recognized. So, but later on, it was also covered, and that's how it became. If you remember, initially the bill was just Forest Scheduled Tribes Forest Dwellers Recognition of Rights Act, but thereafter it became Scheduled Tribes and Other Traditional Forest Rights Recognition of Rights Act, right? So, because the social activists and all, they were apprehended that they were pretty much apprehensive that this exclusion, if they would have allowed that exclusion, that would have led to a societal conflict between the people who were historically living over there, despite the fact that they were not scheduled tribes. So this is a fact which was also there. So that's how the beneficiaries of this FRA was expanded. In addition to that, the act also defines generation. Now, generation, what do you mean by generation? Why it is so important with respect to that? Because when you are talking about identification, recognition of the rights, you have to see that for how long they've been staying there in that forest area. So for how many generations they have been staying there. Now, as per this legislation 2006 FRA, generation means the period which comprising of 25 years, and they are saying that they should have stayed there for 3 generations. That means 75 years, 25, 25, 25. So in order to qualify for forest rights under this act, the other traditional forest dwellers must prove that they have been primarily residing in and dependent on this forest land for bona fide livelihood, and that needs to be there since the year 1930. Now, this is a restrictive provision which was included, and that would, of course, also rendered claims of nomadic tribes and other members of more vulnerable non-ST forest dwellers, who may have relied on other means of livelihood since the year 1930 as ineligible. So this was something which can also be perceived as a discriminatory approach, because this concept of 3 generation was only applicable for other traditional forest dwellers, not the scheduled forest dwellers. For other traditional forest dwellers, they had this 3 generation fact. So the act, in fact, fails to give a proper guidance also, that how you're going to take it into consideration, because you have to refer to the record of the rights. And if you go back 75 years, in fact, from that point, 2006, 75 years, 93 years prior to independence. So whether you will get the records, whether there was any records at all. So the act failed to provide any guidance also with respect to the nature of admissible evidence to be provided in order to prove that particular beneficiary or so-called other traditional forest dwellers can claim their rights under the FRA. So, and the time factor which they have prescribed, as I mentioned, 3 generations, so-called 75 years, it would, of course, take you to the pre-independent era. So it was also argued that if oral evidence or even spot verification will be, sufficient enough, but oral evidence and spot verification were not included as admissible evidence. So a large section of the genuine claimants would be deprived, and government officials will definitely rely on colonial records for the settlement of the rights. So several such issues were also identified at that point of time. But if it goes to so-called other agencies, in fact, I'll come to that, because there is the Rule 13 of the 2008 FRA rules, which in fact provides a very detailed list of documentary and oral evidence for recognition and vesting of forest rights. Although the FRA is silent about it, because numerous people who have resided on certain lands without any formal colonial records, they would have been deprived. So as a step forward, the forest rights rules of 2008, especially Rule 13 of the 2008 rules, provides a very detailed list of documentary and oral evidence for recognition and vesting of the forest rights. But it goes on to the state, then to Gram Sabha and committees that shall consider more than one of these evidences in determining the rights, which would lead to denial of forest rights in many cases. However, Rule 31 of the same 2008 rules have also provided a presumption in the favor of the claimant that in case of any dispute which arises between the claimant and a state agency, unless proof otherwise, of course, there is a presumption which would be taken into consideration. So, this would have safeguarded the interest, but unfortunately, this particular Rule 31 of 2008 draft rules was not adopted. This was not adopted. This presumption element was not adopted in 2008 draft rules. Sorry, the final rules. So in all the cases, you have to identify the traditional link between the forest, your heavy dependence on the forest for survival if you are relying on the forest, and this become a priority in eligibility in order to do that. But unfortunately, despite the fact that there is Rule 2, Sub Rule 6 of the draft rules explain the requirements, but the final rules, when it came in the year 2008, it failed to clarify whether those who reside outside the forest but are very much dependent in the forest for fulfillment of livelihood are not eligible, whether their needs are also eligible for beneficiaries of the act and all. This is pretty much silent about it. So when you could talk about bona fide livelihood needs, the act is silent about it. And in order to remedy this oversight, which may create certain additional difficulties, which also created certain additional difficulties in determination of these claims. Rule 2 of the draft rules proposed a definition at that point of time, which was pretty much similar to that which was there in the bill also. But both of these definitions uh, was not sufficient, and it lacked certain sustainability dimension. So this is one glitch. I would rather say not one. There's quite few glitches in the act and the draft rules, which would have identified these, addressed these problems. But however, unfortunately, in the final rules they didn't pass muster. So that is one reason because of which it was there. Now, when it comes to the rights which were recognized, this is something which is again quite significant, and I'll come to that in a greater detail. That what are the rights which were recognized under the legislation? But if you refer to this FRA, in fact, initially the bill it envisaged that the recognition of the occupation of the land and should be maximum 2.5 hectares per nuclear family of these forest dwellers, scheduled tribes. But unfortunately, the thing is that the so-called the environmentalists, especially, they were of this fear that if you allow that, in that case, distribution of 2.5 hectares of forest land to each India's 20 million nuclear forest dwellers, families, well, it will be a great threat to the forest itself, because we have total we have 50 million hectares, out of which 68 million hectares of the forest land, and that will be consumed only for giving it as uh, under recognized under the Forest Rights Act. So once again, I repeat it. The thing is that it was proposed in the bill that maximum 2.5 hectares per nuclear family of the scheduled tribes forest dwellers will be identified and recognized, right? But the fear of the environmentalist was that if this provision passes muster, which intend to distribute 2.5 hectares of forest land to each of India's around 20, if I presume 20 million nuclear families, tribal nuclear families are there, which is, of course, a total of around 50 million hectares. So, out of the available 68 million hectares of forest land, 50 million hectares of forest land will only be given to this. So, that was a major concern for whom? That was a major concern for of course, for the environmentalists. And for that, there was a article which you can refer. It was from the Hindu by Kishore Rithe, and the title of that article is "When Politics Strike at a Forest Roots." At forest roots. This is from September 1st, 2006. The Hindu. You can refer the same. Now, this was a concern, which, of course, because if you go ahead by that, then only 22% of India's total area is under forest cover, and within that also it will go. So, that was so called perceived as a fresh encroachment, which would lead to fresh encroachments, loss of forest cover, loss of forest land at the same point of time, and there were also certain concerns of other issues relating to forest, like timber and trade, etc., etc. But this particular concern was clearly misplaced, as the bill was merely regularizing the existing tribal encroachments on the forest lands for their livelihood. And even the Ministry of Environment, Forest and Climate Change also argued that the grant of 2.5 hectares of forest land to each nuclear family of the tribal forest dwellers was contrary to the objective of the National Forest Policy, because according to that it like one third of India should be under forest. But if you go ahead by that, then you are going against the objective of the National Forest Policy. But this was contrary to Ministry of Environment Forest its own observation also, because the total area of forest land under encroachment was merely 1.25 to 1.34 million hectares, which is less than even 2% of the recorded forest area in India. So that's the reason because of which the Joint Parliamentary Committee also recommended that the 2.5 hectare ceiling should be removed, and instead, it should sort a grant of forest land as its where its basis, and despite the fact it was opposed by the conservationists. But finally, if you refer to Section 4, subsection 6 of Forest Right Act, you will find a compromise was adopted. Whatever has been adopted is a compromise solution, and it provided for a right of a maximum of 4 hectares of forest land under actual occupation of an individual or family or community. Although there is no scientific or legal basis for this determination, but it is important development, given that fact that over 70% of the scheduled tribes and even scheduled caste landowners in India own less than one third hectare of land. So this is something which was argued and put forward finally. In fact, with respect to Northeast, you will find that there are certain tribal communities in the Northeast which exercise jurisdiction over nearly 300 to 400 kilometers of land. And I'm not just saying that out of anywhere. There is a paper which was written in Economic and Political Weekly from 2005. You can refer that paper, written by J. Roy Burman. The title of that paper was The Tribal Bill, a Rejoinder. Tribal Bill, a Rejoinder. I think it's the 52nd issue. Please do refer to 2005 Economic and Political Weekly, where it was clearly identified that in that paper that certain tribal communities in the Northeast, they exercise jurisdiction over around 300 to 400 kilometers of land. So these are some of the factors which they were pretty much concerned about. Another element of the Forest Right Act is the cutoff date. Now, with respect to the cutoff date, the tribal, rights activists, which also considered the bill's adoption way back, they said that the cutoff date for the recognition of the occupation of this forest land to be too conservative, and they demanded that the adoption of the later date is more feasible. While on the other hand, the environmentalists, they opposed any such extension on the ground that it would lead to a greater loss of forest cover. So there is again another debate between these two, and eventually, after JPC's recommendations, if you refer to Section 4, subsection 3, the Act provided that the forest land should be occupied before 13th of December 2005. However, there is a possible contradiction which is there between this 2005 cutoff, because Section 2O of this act, which also specifies that the other traditional forest dwellers have to be at least 75 years, the three generation in occupation. So the 2005 cutoff date may also be in conflict with there is another policy commonly known as the national displacement policy. It is believed that that was also in contravention to clause 6 of the national displacement policy of 2006, which stated that that only those who project affected families, usually project affected because of any industrial projects or something like that, who were given any possession of forest land which is prior to 25th of October 1980, will be included in the survey of administrator for resettlement and rehabilitation. So these are some of the aspects which were in fact challenging the cutoff date which was prescribed by the Forest Rights Act of 2006. Now, coming to the rights which were recognized under the Forest Rights Act, well, the Act, in fact, grants a series of rights. Please do refer to Section 4 of the same. You will find all the list of the rights. Now, it also talks about grants of, the rights of ownership, access to collect, use, dispose of minor forest produce, but which also includes non-timber forest produce of plant origin, which has been basically collected traditionally, right, within and outside the village boundaries, even in the protected areas. That is something. Then you have the right to access biodiversity and the community right to intellectual property and traditional knowledge, which is, of course, related to forest biodiversity and cultural diversity. It's an important inclusion, and the Joint Parliamentary Committee's recommendation would also imposed an obligation upon the government to protect these rights. That is what it was. Now, in addition to that, there were other rights also which were recognized and which was of quite important significance. For example, the inclusion of the rights to protect, conserve community forest resources. Now, this is something which is important because the community forest concept, as you know, it's pretty much prevalent in several northeastern states, right? And if you haven't followed it, then you can see that, because this right to protect, regenerate, conserve, manage the community forest resources, which is very much community oriented, it has been traditionally practiced, because this protection and conservation or sustainable use has a potential to enhance conservation. But community resource, forest resource, in fact, this community forest resource, it was not defined in the bill itself, and it was also very much unclear whether this rights would extend to those forests which are government-owned forest. However, if you refer to Section 2, Clause A of the Forest Rights Act, it in fact clarified this ambiguity by including resources within the reserve forest, and protected areas like national parks and sanctuaries, which had been on the community, in which the community had traditional access. So, in a way, this bill also included the right to impose penalty or anyone who's violating this community rights or traditional rights of conservation, but the same has not been included in the act. So the bill was quite comprehensive, but the final legislation, in fact, missed out to that. Now, in addition to that, the inclusion of the right to in situ rehabilitation, including this alternative land in the cases where the scheduled tribes or even any other traditional forest dwellers, if they have been illegally evicted or displaced without receiving proper, entitlement or compensation to rehabilitation, and if would have been done prior to 13th of December 2005, then in that case there is a measure which has been taken. Now, from this perspective, of course, if the reason of displacement or dispossession is some development project or natural disaster or even failure of the state to provide them, then in that kind of situation, an alternative land should be provided. This element of in situ rehabilitation has also been provided, and this is something which you can say is a very good side of the Forest Rights Act. There are certain obligations in addition to that. Now, the obligation is that you have this gram sabhas, right? And these gram sabhas are pretty much empowered. These are so-called village level institutions, as you all know, in several areas across our country. And if there is any forest rights holder, inter alia with respect to a particular wildlife, forest, biodiversity, then you have to, in order to ensure their habitat is protected, preserved from any kind of destructive practices or intrusion in that kind of situation, the Gram Sabha has been empowered to identify that and recognize and protect their rights. So this is something which you will find under the Forest Rights Act, that the Gram Sabha plays a very, very significant role to ensure protection, conservation, recognition of not just the forest land but also the forest dwellers at the same point of time. And this is something which there are also certain light legislations which is quite significant with respect to that. Now, the light legislations, for example, if PISA that I have just mentioned, that is important, and this is something which is again important. You should read it in alignment with the PISA, the Forest Rights Act, and PISA should be read together. Now, the thing is that in addition to this, there are certain procedures which were also established. Now, the primacy of the Gram Sabha was a move towards the decentralized framework that we have in our country right now. So that was a move which, of course, because this act is the first legislation of a country, you can say, which in fact very, very clearly and elaborately lays down a procedure for not just determination on the nature and extent of the forest rights, but also to ensure proper implementation of the same. And the Joint Parliamentary Committee's recommendation was also based on this community control to counter the monopoly of the forest department, which was perceiving these forest dwellers as encroachers for quite a long time. So much of power was vested with this Gram Sabha, with the sole authority and responsibility to settle the rights of the forest dwellers. So it is up to the Gram Sabha. Now there are several stages which were also there, levels I would rather say, and these levels were like the act in fact requires each and every state government to constitute a subdivisional level committee. Then you have a district level committee, which is headed by the district magistrate. And then you have a state level monitoring committee. And at first stage, the subdivisional level committee will examine the resolution passed by the Gram Sabha. So whatever Gram Sabha decides, recognize the rights of forest dwellers, etc., it will pass it to SDLC, subdivisional. And subdivisional level committee will look into those Gram Sabha, although they can even veto the SDLC's decision, but the decision of the district level committee is final. So Gram Sabha will prepare the record of the forest rights, and which it is considering, and it will forward it to SDLCs. Then SDLCs will have it a look. Although Gram Sabha has a veto was the SDLC's decision, and then it will be forwarded to the district level committee, and district level committee's decision is final. Although the Act it does not clarify whether the SDLC, or so-called the subdivisional level committee, or even the district level committee are to consider the ecological implications while rejecting or even approving the rights of the forest by Gram Sabhas. But Gram Sabha enjoys immense responsibility and power. It is empowered at the same point of time. So the subdivisional level committee and the district level committee are responsible in a way for considering and disposition of any petitions which are in fact preferred by any aggrieved person against any resolution of Gram Sabha. There is a checks and balance in a way that whether the Gram Sabha should not also override an exercise which it is not empowered to, whether it has misused its power, abused its power. In order to check that also, the element of such petitions to be disposed of by the DLCs are also mentioned in the Act. And there is a clear hierarchy which has been mentioned in that entire process, as no petition against the Gram Sabha's resolution can be preferred directly before the district level committee. It will go through that hierarchy. However, the committees are not mandated to provide the Gram Sabha with transparent and prompt feedback. But there is a element of reasons of decision that has to be done. But any failure to specify the time limit for determination of this claim by various committees may also cause certain delay in the grant of forest rights. So this is something which is there. The enactment, in a way, also requires, the so-called the state level monitoring committee, so called the highest authority in the state, SLMC, to monitor the process of determination of these so-called forest rights and to submit a return and report to the nodal agency, which is the nodal agency of what? Nodal agency of Ministry of Tribal Affairs. So the state level monitoring committee will monitor the entire process of the determination of rights, which is starting right there from the Gram Sabha, then going to the subdivisional level committee, then the district level committee, and finally to them. And they will prepare that. They will prepare and they will file the returns and report to the nodal agency of Ministry of Tribal Affairs, or any officers or authority which has been authorized by the central government to do so. So this provision, in fact, effectively allows the central government to overrule all the decisions taken by the grassroots level. So that is again a power which the central government enjoys with respect to that. So this is the institutional structure and the procedure of recognition of the forest rights as per the Forest Rights Act. There are critics who believe that this so-called procedure, institutional framework, is pretty much favoring the bureaucracy, etc., etc. Yeah, because the composition, if you see the composition of these committees, the participation of the people, etc., the bureaucracy has terribly failed to regularize the land which are occupied by forest dwelling communities, despite the passage of considerable time. So there were certain critiques which are pretty much there, but that is something which is in fact important also, because this is something where you will find this institutional framework plays a very significant role for something which was not even there previously, to balance the historical injustice. That is something which is required. And this process, this due procedure which has been established by the Forest Conservation Act, it aims to implement and finalize and regularize and recognize the rights of the forest dwellers. So this is what I have for the Forest Rights Act 2006. Please do refer to this legislation and also read the article that I have referred. And you can also refer to other articles. You will find a number of articles on Forest Rights Act available on internet. So in the next class, we'll look into other avenues of environmental law. Until then, stay safe, stay home, and take care of yourself. Thank you very much.